And here we are with a motion now to dismiss, to suppress, because the consent agreement was just for the text messages between Anna and her husband Brian, and not for any other data. So Michael and I have been batting this around because we think that you would have the answer that could you get to the same, let's assume this gets suppressed, could you get to the same information by going to towers and looking for where his cell phone was, where the wife's cell phone is? And in terms of law enforcement, the kid's cell phone, is it owned by the kid who's under 18, or is it owned by the person who's the account holder? And you could shed some light on all of this. And that's a lot there I just talked to you about, Michael. But do you think we're trying to get to the point that we think that this could be inevitable discovery, that this information is found out other ways besides the improper and possibly and likely illegal way that this information was?
Yeah, and let me just add one. We haven't gotten a decision yet, and my belief is that the court is trying to find a way through inevitable discovery or some other to not suppress the material. So let's get your take on that, and then just go through the mechanics of, okay, I've got a graphic here about all the geolocation info that they theoretically did not have the right to look for. First question: how common, in your experience, is it to have consent for one of these devices rather than a formal search warrant?
And in this type of situation, it's more common.
Really?
Yeah. I would suspect that they did why I would do it, which is it's a test. It's a test for the person you're interviewing. That's I've worked several of these, and if you haven't worked these, well, those guys have worked enough to know that my first instinct is that the husband is going to have some role in an adult female wife missing, unless she's a true gone girl, which I've worked the Sherry Papini case out of Mount Shasta. I worked that when she was a gone girl. But to kind of bring back to this is that I would use it as a test of him to consent to me looking at your phone to determine whether he is on board with us finding her. And if he's not going to consent to it, it would make me a little suspicious. Because I think if you were to just ask yourself, if your loved one went missing, would you have any reservations of giving up any information on your phone to find your loved one? And if one of my daughters went missing, you could come search every nook and cranny of my house. Of course. Because I wouldn't be there. I'd be out running the streets finding her myself. Right. But I wouldn't. Yes, here, look at it now. Get the person here. Let's start downloading these things immediately. I want this. Whatever you need, it's yours, right?
Okay, so follow up to that is how far does that consent go? In your scenario, it's like, here's the phone. Whatever you can find, use it. Not the scenario they had. According to the defense, it was very limited. And therefore, anything beyond it, which gets us to this location information we'll look at in a moment, is a violation of the defendant's rights and fruit of the poisonous tree, Fourth Amendment search and seizure violations, et cetera.
Mm-hmm. Okay, let me answer that part because I was just going on my own tangent. But
by the way, your own tangent, Joanne Jetopoulos was a member for 4 months. She's been following us for a while. You're her all-time favorite guest. So when you go on that tangent, remember you got big shoes to fill there because all-time favorite.
Yeah, that's impressive.
Please tell me you've had more than me as a guest. Then.
Yeah, you and one other person. That's all. That's all we've had. So.
Me and baby me is the only guest you've probably had then, right? No, you bring up a good question. Is that when I listened to some testimony specifically, and I heard on YouTube of that hearing, the evidentiary hearing, and I heard the defense or the prosecution read in some of the testimony or the statements, the interview of Mr. Walshe and the questions. And hopefully this doesn't anger too many of your viewers, but I found it a little unclear on whether or not Brian Walshe did consent to a full extraction with the knowledge that they would use all of the extraction for their personal and for the investigation. it seemed to me that could have been clearer. And the way that's done clearer is when I've done it is we would clearly what they did is it's through an interview, it's recorded, and then I would draft up, or we actually have a form in the Bureau, as you can imagine, is a consent form, a consent to search. And in the consent to search, it is not only witnessed by another party, which would sign with me that we both observe this person consent, but you're going to have a very specific description of the item or place to be searched. We'd have a very specific description of the device. And that would either be a visual description or a photograph or the internal serial number or the phone numbers. It would include what evidence we seek to search or collect from the device. So we would enumerate very clearly that we're going to extract these things for this date range. It would include a receipt for property so that we would give them the pink slip of it's a triplicate copy. We give it back to them so they know that we've taken it. We would document what the product or the item looks like so that when we give it back to them, they don't go, well, you broke my screen. You owe me a new iPhone, right? Which you guys could imagine certain instances that could happen. And, or, hey, I gave you an iPhone 14 and you gave me an iPhone 10 back. And it's like, well, no, I didn't. It's like, well, prove I didn't give you. You know what I mean? So it starts getting to that. So I would say what I didn't see in this case, what I would have liked to have seen is, I think Lieutenant Fanny's the one that first collected them, is I would have collected them through a property receipt that could serve as a chain of custody for it. And then a consent to search that would have been signed by me, a second party, and the person I'm taking it from, so that they could see very clearly, these are the things, just like, you know, you guys are lawyers, just like you would put in items to be seized in addendum A of a search warrant, right? You would have that in a search warrant. So you are simply, this is a search. You're just asking for them to consent. So you should describe the items to be seized and the items to be searched. And I think, could you imagine if that was done? I think we would see a very different evidentiary hearing because they would have had it written down. Well, you did consent to all of these things and you signed it.
And that was the problem. I mean, now they're talking about what was said and whether a follow-up email reinforced what was said. It's a joke, but I think what you've just described is the vast difference between the FBI and their process and the Massachusetts State Police and their process. Very different.
But I agree. And I think what you're seeing still is a culture that was at the Massachusetts State Police for that Norfolk area, in that this happens in January of 2023. They don't have their investigative practice exposed to the world until April of 2024. Right. So they're still within that operating system that this is how we do it. And I can't imagine that's still happening today, or I hope it's not. But you know, they're going to live with the mess they created with these types of this type of policy or process. And especially the same investigators. We saw the same band of characters that we saw in Karen Reed's case.
It's frightening.